around afterwards and answer questions, if that's fair. We've had a discussion about the microphones not being able to be picked up. We talked to the people that installed these, and these are basically whoever talks the loudest gets the mic, and the other ones are shut off. So if there's somebody discussing something and somebody's clicking a pen or the phone goes off or they're clearing their throat, it could impede what people are hearing. And just sit a little closer to the microphones and we'll see if that works. Otherwise, I've talked to Anne Marie and the chief, and we'll probably tase anybody that sits back too far in their chair.
All right.
It'll have to be a resolution, but we can discuss it. Call this meeting to order. With the clerk call the roll, please.
Allen,
Here.
Perkins,
Here.
Green,
Here.
Swisher,
Here.
Guthrie, Thompson,
Here.
Brandt,
Here.
Cook.
Here.
I'd like a motion to adopt the agenda.
So moved.
Is there a second? Roll call, please.
Thompson,
Yes.
Brandt,
Yes.
Cook,
Yes.
Allen,
Yes.
Perkins.
Yes.
Green,
Yes.
Swisher,
Yes.
Guthrie.
Okay, open the floor for discussion. Would one of the council members that called the meeting care to discuss maybe what we're talking about tonight?
Yeah, I was just curious if we could figure out a resolution to Councilman Drew Green's issue without the use of attorneys and see what we could talk about and find out what the story is.
Josh? There has been something filed, actually, a legal document filed.
A resolution was prepared and approved by the council. And so I believe that resolution sets forth the process to be utilized in determining whether discipline should occur or not. And so, yeah, but I think the council can amend that resolution or change the procedure if it chose to do so.
So is the, originally what was set forth for a trial still on the table? Is it off the table? Where are we on that?
Yes, as far as I know, that resolution was approved, and that was the last resolution approved related to the matter.
So it'd be first and second reading, excuse me.
I believe it was just, I believe it was just a resolution.
Oh, okay, that's right, okay.
So it was read
I
once.
apologize. Yeah.
So, I was not here in the beginning of this, when all this came down, so-called came down, or did come down, didn't come down. I'm a latecomer to the table. Something needs to happen. This needs to come to a head so that we can move on and do what we're here to do. We're not here to try to figure out whether Drew did this or didn't do that every meeting, in my opinion. We need to come to some sort of a resolution as to what we're going to do with this. I feel like that we're to the point that it's not an in-house thing. It can't be an HR thing because we're not employees. We are elected, so it cannot be an HR thing. We have to have someone or a couple of people, lawyers, whatever, be the guidance on this. In my opinion, I don't feel like we can be the judge and the jury, both. And I believe we need to get this thing to go through. We need to be able to proceed, perhaps as we started this, to get it done and have the lawyers take care of it. I mean, how's anybody else feel about this?
Outside of what's already set forth, what other options are there that exist?
The guidance is that, so the council is sort of in charge of policing itself in terms of, council behavior. And so, and whether, what rises to the level of, discipline being necessary. The ordinance that the city has simply specifies that the council kind of acts as the arbiter of that, it's the decision maker when it comes to discipline or not. And then it's up to the council to determine what kind of procedures that it utilizes to make those determinations then. And so it doesn't go anywhere beyond that in terms of specifying, the trial must occur within a certain period of time or a trial must occur. And so, it's up to the council as a whole to determine what process to use.
I'm going to jump in, even though I'm not a council member on this one. We had a letter from Paul Martin that suggested perhaps mediation wasn't even possible, or is that just because we have a hearing scheduled and mediation would be possible if there was no hearing?
I saw that communication as well, and I took it to mean that he intended to talk with Mr. Green's counsel to see whether there was some discussion that could be had short of even having a mediation. And I don't know whether any conversations have taken place in that regard, though.
No, I did talk to my attorney. The way I think it was left, which in my understanding, which is why we're here tonight, was that at the end of that letter, Mr. Martin suggested a censure, which I believe people felt like that brought it even to a lower level than mediation. And they felt that if we're going to censure, basically I think he suggested both attorneys get together, look at everything, and then come up with a letter of absolution, basically a censure level, or a letter just saying, this side this side that, here's our letter, you guys do whatever. But I did not get out of that letter, neither did my attorney, that they were supposed to talk. I think, like they said in that night when I read that joint statement, they're waiting for direction from counsel. And so I think Paul Martin was suggesting a censure, but he didn't, after he had time to think about it, he wasn't really for mediation, since there was no monetary value, is what I got out of that letter. And so he was looking more, if we wanted to do something like mediation, that he suggested a censure. Which, like I said, then got some people up here, in my understanding, to believe that, well, if we're going to do that, then what's the point of having the lawyers involved if we're just going to sit down and talk about it and decide what needs to be done? And I guess that brings me to a question that Phil brought up about counsel not being the judge and jury. It's my understanding that that's exactly what the counsel is in this situation. I mean, they hear all the evidence, whether it's a trial, whether it's, and they are the, like you said, the disciplinary enforcement.
Counsel's the jury, that, I don't know, I can't remember their name, Boyd and Kempner or whatever, is,
Well, he's a presiding judge.
The judge, yeah.
But he doesn't have any authority over what council decides, which is why I say, that's just why I say,
which makes us the jury.
and the
Correct.
judge, for that matter. I mean, you guys, he has no authority to overrule you or,
They would be laying out the evidence
Right,
that
and the judge.
you've got
facilitate
both
that.
sides. They would be facilitating.
He's a facilitator.
And presenting both sides to where then we made it,
Martin
decision.
said.
but it's not like in a
And-
court where he's a judge, is what I'm getting at,
Correct.
Josh, is that?
I kind of view it as sort of an administrative, and so
Right.
you have a hearing body, and then you've got someone that chairs it as sort of a hearing officer, and the purpose of the hearing officer is to provide guidance to the council. So if there's an objection to some evidence that's presented, then that hearing officer can advise the council as to whether that evidence should be allowed in or whether
Right.
the objection should be sustained. But the officer ultimately doesn't have any vote or input into whether discipline is necessary or not. That falls on the council to determine that.
Which is why I was saying that the council is the judge and jury in that respect, because they not only say, hey, we find them guilty, they also have to have the punishment on top of that, and not the judge and set sentence. So anyway, no, our attorneys haven't spoke about that. They're waiting for guidance from council, and that's why I thought we were here tonight, to talk about whether we wanted to do something more along the lines of a an attorney comes in and we kind of talk about it amongst ourselves and show evidence and decide what we want to do without spending money, yeah.
And I know we talked about mediation, and I'm not sure how mediation would work in this kind of a situation, because you really haven't come up with all the facts yet. So, you know, we have all these allegations. Are they all proved? Are they all correct? We haven't proved or disproved any of them. So we really don't know so, you know, I've been involved in a lot of mediations and arbitrations over the years, and I just, without knowing what exactly happened, I don't know how we can mediate it. The only way I could think we could do that is we come to, terms of what actually happened. I mean, if we assume that everything in the allegations is correct and stipulate that everything is correct, you know, all the allegations, then we can go from that point. But without presenting evidence from your side, the other side, we don't know what's actually happened yet, you know. We haven't proven what's happened. We've had allegations, but we haven't proven what's happened. So, you know, I'm all for trying whatever we can, but I don't know, mediation doesn't work until you know what the facts are.
And I think the mediation draws out the facts, but I would disagree. I mean, not disagree. I agree with what you're saying. And that's kind of the point, I think, of why we're here, is that some people feel like we can get into an executive order about disciplinary action and hear everything and then decide what you want to do after that without wasting money. That's the way I understood it. But I'll leave that up to these guys.
Yeah, I think that's, most of my question there is what options are on the table, and if it's for council to decide what that next step is. Me just trying to understand, with it being in the phase that it's in, is what options do we have to go back and possibly look at other avenues. So I mean, I'm not in favor of, personally, I'm not in favor of, you know, spending money on a trial that, you know, it appears that there's other ways to go about having the discussions that are needed, and, you know, coming up with maybe even a better outcome. Again, I'm new to this too. New to the information that I've received just from council meetings and seeing it, but I do agree with Mr. Perkins in that it'd be great to do something and move past it, so we can, you know, we can look at other things. But you know, it sounds from previous meetings and information, just my understanding is that that Drew and his representative and the city attorney or whoever, or the attorneys involved, haven't even sat down and talked yet. To get, I mean, Drew, have you had a chance to give statements and all that yet? And so it really feels cart before the horse, and it may, I don't know, maybe it ends up in trial at some point, but doesn't seem that trial is the starting point.
We keep pushing the cart back. The cart has got to get out front so we can do something. If the allegations against Drew, if they're not true, then there's nothing for Drew to fear in having his day, so to speak, in court.
I mean, there's defamation of character and everything that involves with unnecessarily going to any type of trial if there's no reason to. I personally wouldn't want my name dragged through anything that there wasn't credence. And I think just,
But if it didn't happen, then it's not a problem for him.
but nobody's talked to Drew about.
So I'll answer that.
I think you've had
because-
opportunity to talk, though.
No,
and
I
we-
have not. Nobody's asked me if I've done any of these things, Phil. And so I'll get to the point real quick, because I'm tired of hearing stuff like that. Basically, because of the way it's been done, I'm guilty before having a chance to be proven innocent. And you want to go spend tens of thousands of dollars on a trial of the citizens' money with no skin in the game, to have a trial when we could sit in a room under executive order and you could hear the evidence and make a decision then. If you want to go to trial after you hear my evidence, let's go. I have nothing to fear, like you said. I'm trying to be a good fiduciary of the citizens' money and realize that if we're all going to be adults, let's sit in a room, let's talk about all the evidence, and we come out of the room and make a statement. But going straight to tens of thousands of dollars of the citizens' money just seems irresponsible. But like I told Mr. Martin in my email response when he gave me no reasonable opportunity to make a statement, you have already drawn some people to a pre-concluded decision that I am guilty. And we see it, and I hear it from statements like that, and I know there's others, and I get it. The accusations sound horrible on the surface, and they're hard to look at, but not one person has come to me out of the people that are pushing for this and said, did you do any of this? What about this one? What about this one? They've never asked for a statement from me, so that's my answer.
Tough one. But I'm like Phil, I just want this to be done. So we need to come to some sort of deal. If it involves, I don't know how to put this. So you have not talked to your lawyer about this stuff or counseled with him or anything? Is that what I'm hearing?
Say that again, I didn't quite get that.
So you haven't, like, talked to your lawyer about this stuff that's going on or the allegations or whatever?
No, I've talked to him about them, yes. I had like that meeting a couple of weeks ago, I can't remember, that Tuesday, April 11th, my first meeting with him. We went over the allegations and talked about these things. I was saying earlier that since the proposed mediation and then Paul Martin's letter, everything's been pretty much on hold because he mentioned censure, and if we're going to do that, then let's just have an executive meeting and decide amongst, if we're the judge and jury anyway, then let's just hear the evidence and you guys do whatever you want to do as far as discipline instead of spending thousands of dollars. But they haven't talked anymore about that. They're waiting on direction from us.
So Josh, like, do we know how much it would cost just to, like, get through this stuff with, I guess, mediation with two lawyers or whatever?
I mean, depends on how long the mediation would be, I guess, but, I mean, so it's just based upon I wouldn't anticipate that you have the hearing and the officer involved, so it would just be Mr. Martin and his raised whatever time was involved in participating in the mediation.
So Drew, if I'm understanding censure correctly, it would entail this group getting together in executive session, having dialogue and discussing the issues at hand, and then coming up with a proposed solution to the ordeal. Am I catching that?
I'm going to have to lean on Josh a little bit. The way, the censure part from the letter was Paul Martin and Kenton Kinney discussing the issue. Now, I would have to ask Josh, can that same outcome happen in an executive meeting about disciplinary action towards me, where we discuss the evidence involving personnel and things like that, and then they basically have a discipline? I don't know the answer to that.
My understanding was the same as yours from that last correspondence from Mr. Martin, which would be that your attorney and he would talk about potential resolution, and he would report back to the council, and that's what, I don't know if any of those conversations have taken place.
Yeah, they haven't, because I think they were waiting for us to say which way we wanted to go. Yeah.
And I think the uncertainty with the mediation lies in part in the typical sort of litigation context, like if the city were involved. Typically, if defense counsel is provided by insurance company, then if mediation is ultimately held, the city administrator and like the mayor typically would attend that mediation. If there's some kind of resolution that would be reached, it can't be finalized there. It's brought back to the council for final approval. And so this is a little bit different in that, ultimately it's the council that is, that you're sort of the hearing agency or the administrative body that decides discipline. And so, so I think that's where the kind of the uncertainty on how to approach a mediation lies. How would you do that and kind of be fair to the parties that are involved?
Josh, I've been reading up on this a little bit too, and I haven't come to a conclusion. Does this have to be done in open session, or can it be done in executive? My opinion, from what I've been reading, it has to be all open, since it's not a personnel issue.
Yeah, the actual trial itself would not be, it would not be able to be, you wouldn't be able to close it to the public. And so, yeah, that raises some concern, I guess, on mind of things, that if that is the case, then, likewise, you may not be able to have a meeting of the council and sort of have a mediation, kind of in the sense that we all think of mediation, without it being open to the public as well. And I don't want to say that's a firm, a firm answer on that particular issue. We can certainly look at that a little more closely if you'd like for that to happen. But there's some question whether, in my mind, whether we can do that or not. We want to look at that a little more closely, I think.
So we can't go into closed council and do what Drew's saying either, then?
That's why I don't want to say with certainty that that's the case, but if the trial is going to be public, I'm concerned that some of those discussions might also be subject
Right.
to being an open meeting. So I will say I haven't devoted any time to looking at that to confirm that, though, at this point.
Because I'm just trying to come down to the base points of understanding why we're here tonight. There was the trial, which I think, everybody knows gets expensive. There was a mediation that might be a little cheaper than a trial, is the way I understand it. And then with the letter talking about censure, then a question was arisen, well, then, can we even do a cheaper route than that and basically have the same outcome? So I think that's what we're trying to decide tonight. Now, the end of that is not, the end result should be the same no matter which route is chosen, is the way I understand it. All evidence will be out there, and the decision will be made by council in any of those decisions. It just really comes down to how much money is spent. Am I understanding that correctly?
If there was a hearing held, ultimately there'll be decision about whether discipline is necessary or not. With a mediation, or, to the council, for the city and your council, Mr. Green, communicating. I suppose, both of those options are on the table still too, as far as discussion goes. So, whether discipline is necessary or not, or something in between, could be discussed at any one of those levels that have been mentioned. One thought I had maybe would be to ask, apart from the letter that came through from Mr. Martin most recently, I've not had any contact with him. That's the last communication that I saw that came from him, but it sounds like maybe, ask him to provide some, something to council in terms of what he would recommend the approach be, or what he envisions the approach being, and have him lay it out for you what he thinks would be the best approach to take under the circumstances, and then move forward from there.
Well, we'll still have the same argument if Mr. Kinney isn't involved in that, I think.
Well, and I'm just talking about, provide some direction to the council as far as what he thinks the appropriate, structure for a mediation, or, just contact between attorneys would look like. And I think that and Ms. Lewis can correct me if I'm wrong, but I think the council, at one of its last meetings, I think there was a motion that was approved to have mediation of some kind. And so I think so I think Mr. Martin, in his letter, indicated that there would be an effort short of mediation to resolve the dispute, but I think what's lacking here is just some framework for the council to know what will mediation look like, if that moves forward.
I may be misremembering this, but I think what we agreed on was to allow for the possibility of a mediation if both attorneys and everybody agreed to it. That was
I think
by no means saying that that's the way we were going. That's just another avenue we were gonna look at.
Yeah, I think we were,
And
again, assuming by the time we got together the next board meeting that the two attorneys and Drew would have opportunity to see if it was a possibility or not, and if that wasn't, we were gonna move forward with something.
And I think in fact, Mr. Lutterby even said, you know, something by the next meeting on May 1st. And if nothing was reached by then we'd do something else, and he might look into finding a mediator or something like that.
Would this be acceptable? It doesn't have to be by May 1st, because it probably won't happen. But in the next, give a certain number of days for the two attorneys to get together, get back, discuss it with Drew if necessary, and come back with something. We could send that as an email out to everybody, announce it on maybe the 15th as to what the results would be and how we're gonna, I don't know if that would be appropriate or not. If that's something, I wouldn't mind if they sent everything to me and then I can disperse it out to the council and we could have that meeting and the discussion on the 15th.
We're gonna be racing the clock here because we've got a disciplinary hearing committed or scheduled for the 24th of May, I think. And,
Whatever day, it's late May.
yeah, so whatever we decide, I don't think we wanna go much past the 1st.
Yeah, it could be a date between now and the 1st, and I could have the recommendations emailed out to all the council members, and we could even have another special meeting if we needed. But I think it could be resolved if everybody's in agreement that which way we're gonna go forward at that point on the 15th. Whether that's gonna still be the hearing, or mediation, or censure, you know, some sort of censure.
Yeah.
I don't know, would your, and
Again, I just, you know, I agree with what Steve said, that was the idea, and I think the letter from Paul Martin talking about censure kind of raised some questions about, do we need all this? But I am happy to have my attorney call him, and like they said, you know, now that Paul Martin's letter came out and he had time to think about the joint statement they made, he's not for mediation, but I don't think he's against it per se if council leans that way. I personally don't know much about mediation, but what I've learned, it seems like the parties are in separate rooms and a mediator bounces back and forth. So that doesn't allow council to hear the evidence.
That's more like
That's an
arbitration.
arbitration, I believe.
Is that what mediation would be like, Josh?
Arbitration is different than mediation.
I mean, it varies, it can look different, sometimes, parties are in separate rooms, sometimes people are in the same room, in a conference room across the table from one another, at a mediation as well, and so, a lot of times the mediator will, you know, discuss with the attorneys that are involved, as to, is there a real animus between the parties, or is it something where they could be in the same room and discuss the case or not, and then kind of develop an approach that both sides can live with?
Because I'd be more for that than in separate rooms. I don't think being in separate rooms does a whole lot of good. But I would be more for something like that, for sure. But then again, you're in the room listening to everything. What's the need to be paying $200 and $250 an hour or whatever it is, if you're just going to get in a room and go through the allegations and say, well, here's what I've got, and here's what, you know.
So if we go through this process and we come to the conclusion as a group that you have done this, are you there to accept that, or where do we go?
Well, I don't have a choice but to accept it. I'm not sure I understand the question. If council votes
Well, I
for
understand,
censure or
but-
whatever, I mean, what am
but
I supposed to do about that?
We just keep putting it off and putting it off and putting it off. Somehow
Okay, let's talk about it right now.
we've
then.
got
Get
to-
out the sheet, let's talk about it.
we can't,
let's go through them. Ask me. We got Julie here, Josh is here, JD's here. Pull it out.
I would recommend that we don't do that tonight.
I'm not trying to put it off, and that's the suggestion I get from you, is that I'm trying to drag this out. I'm not.
I think we actually, like Josh had said, I think we need to find somebody, find out what we need to do, get it structured, and then go at it, and just knock it out. But my personal deal, just want this to be done. We need to move forward, because if it costs $2,000 to get it done, let's get it done. We got other stuff we should be focusing on. That's just my personal opinion.
There's gotta be a lawyer on both sides rather than just us that are discussing the facts. And I'm not sure how that goes about, what we need to do, but I feel like it can't just be us making this decision. We have to have a couple lawyers. It's gonna cost some money. It is what it is.
Just for my own sake, to make sure I understand correctly, there's not a scenario that involves just the members of council sitting and discussing the allegations or alleged or the charges and coming up with disciplinary action within the council without outside legal counsel. I mean, there's not an alternative where,
No, the council can do that. I think the question is, the question there would be whether it would occur at a public hearing or could occur in a closed session of some kind.
So what we really lack is a framework to make that work. So hearing evidence from both sides and who actually even represents the city on the act, or those, from that. So, I mean, as long as you set up both sides, can't we have that pretty easily?
Do y'all remember here, I don't know, it's been 15 years ago, maybe 20, whenever the school board decided they were gonna get rid of Dr. Gordon? They had it was a hearing, a disciplinary hearing. They didn't opt to get the facilitator, and this thing turned into a circus. I mean, it was just a flat nightmare. And Dr. Gordon gave up all his claims and just got up and walked out the door. And they lost a lot of people over, and the school board lost a lot of time and respect that they still haven't got back. I don't know that we wanna put ourselves in that situation, and what we're talking about here is basically one thing, and that's foregoing this, I forget what their name is. I keep saying Boyd and Kentner, I don't know why, but Boyce and Bynum, who is it? Engelmeyer. Yeah, I think we're just talking about foregoing that, is basically what we're doing. And I don't see the point in it, and if we're talking about taking this behind closed doors to settle it amongst ourselves, all three of you guys run and won on transparency and accountability for city council members. All three of you mentioned treating city employees well. This whole thing arose from complaints from city employees about Drew. I have no idea what's true and what's not. I don't even know what the complaints were. The only thing that we know, unless someone has told someone something, is what the charges were, and there was 5 or 6 of them. I don't even know who's involved, and whoever's involved, every one of them is gonna have to agree to mediation. Has anybody asked them? Does anybody even know who they are? And the only way we're gonna find this out is to just drag it out into the open, just bite the bullet, and rip the Band-Aid off and do it, because I've said it before, there is nothing more transparent than a public disciplinary hearing. I've been in on enough of them, and luckily I've never been the subject of one, but it's very uncomfortable for everybody in the room.
yeah, I'm sorry, go ahead.
Well, and I just think if we're truly interested in taking care of our employees and protecting them, then, and if we're truly interested in transparency and being fair, this needs to be done. This, the way we have it, we need to go through with that hearing on the 24th or 25th, whenever it was. We need to, and get it done, and then just get back to the business of taking care of the city's business, which is the only reason we should consider ourselves to be here. Is to take care of the business of the city's business. And if there's not enough proof against Drew, then we need to protect Drew and find out the nature of these claims. And if they're false claims or whatever they are, we need to deal with that. And if there is enough proof against Drew, then we need to deal with that. And just be done with it.
Yeah. So a couple of things that you mentioned, protection, city employees, and I agree. I mean, I don't think anybody would say otherwise, but I think there's some protection that should be extended to fellow council people too. You just said yourself, you don't know the details.
Don't know. How are we gonna find out?
I think the first step is for Drew to be able to discuss those with the council, right?
We gotta know what they are first.
It's gonna take discussion to get those details. I don't think dragging somebody through a trial, and dragging might be the wrong word, but I don't think that's protection. The transparency, we're not operating right now with any transparency. We haven't had the discussion. The discussion hasn't happened between Drew and both councils to come to us with some sort of remedy for the situation. It's straight to trial. The part that's really bothersome to me is that we're just straight to trial. There's a monetary aspect, there's a fiduciary responsibility. So I personally, just in good faith, I can't say, hey, I agree that we just push this thing to a trial. If there's other avenues that are cheaper and would produce the same result. Whether it's saving $2,000 or $3, I think we owe that to the citizens. It's their money, and so just throwing money at something because we want to get it over with, I don't think that's fair either. And I had a note here, and now I can't read it, but I should have been a doctor, at least for the handwriting. The damage, I think what's being missed by some, or just maybe through some of the comments, whether or not somebody is found to be not guilty in a trial does nothing to repair the damages that are done to that person as that happens. I mean, just the fact that it's to the point it is already an attack on character, whether valid or not. And I'm not saying it is or isn't. I don't know the details. I'd like to learn more before I say, hey, my vote is that we spend taxpayer money to have a trial that may not be necessary if there were other means to resolve it. If it's just to get to a point to say, hey, vote Drew Green off the council, I mean, just make a motion to do that. What do we need trial for? I don't even know if that's a possibility. It just feels like there's this predetermined, we have to do something to discipline, but we don't know what we're disciplining. That's at least my take.
Well, I think we're all in agreement, we need to find out what. I think the disagreement is how.
Yeah, and it can't just slide under the table and say, slap him on the hand if don't do that again. It can't, it's gotta be something.
What has he done?
Yeah, don't do what again?
We don't-
If it is proven that you did.
We don't know, we don't know.
We don't
the
know at
facts
this
yet.
point
But
until
I'll
we
be-
go through it.
I know Drew, I mean, when I hear that though, it's like it's predetermined. Like, when I hear that, I didn't hear it if. I mean, it was said, you can't let that slide, it can't be, why? If there's nothing that's been proven to be done yet, why can't there be a slap on the hand or nothing done? If you meant to preface that with if, my apologies.
I followed it with an if he did. I'm sorry, I didn't say it if
Okay.
in the first sentence there. If he did anything, it has to be addressed.
Sure.
It cannot be pushed under the table.
So the fact of the matter is, we gotta find out what happened before we can do anything.
Correct.
I think, do we all agree on that?
Yes.
We have to have the facts before we know. Now, is it, how do we get the facts? Do we go to a hearing to have the facts? Or do we sit down as a group and lay out the allegations and you respond to every allegation? Then
Right.
we go and interview all the employees involved and dig up YouTube videos and emails and texts and everything to present the facts so we can make a determination whether the 6 or 7 allegations were true or not true. We can't do anything until we do that. So
Right.
how do we do that?
Or do we
Do we
have,
do the hearing, or is there some other way? So
I think that was
that's the
my,
only thing that's on the table right now.
isn't that what the two lawyers would be doing?
Yeah, that's a way to do it.
I mean,
Yeah.
rather,
So-
they would be getting the facts gathered together to present back to us
Yeah.
instead of us going around door to door trying to figure out what did or didn't happen.
So, Josh, well, let me ask counsel this. If we take Mr. Martin's letter and they discuss a censure on whichever side, do you all trust, if they get together and look at all the evidence, that whatever they bring is what they bring? Are you going to be done with it at that point? Because that doesn't involve us. That involves them looking at all the evidence and deciding what needs to happen. And then they bring their recommendation. Are you going to take that?
I can't say that an attorney representing us and an attorney representing you are gonna come to terms to what your punishment should be.
Well, no, but like the letter said, and if I'm understanding that right, Josh, that they get together, look at everything, and then make a recommendation of it needs discipline or it doesn't need discipline.
I got it right here. I can read it.
Oh, please, yeah.
It says, I suggest in lieu of meditation, Mr. Kinney and I confer about the possibility of a stipulated resolution of censure, including an agreed-upon code of conduct by which all council members may be governed on a going-forward basis. Mr. Green would need to accept some responsibility for his actions, but the censure need not be overly damning. If the council was in favor, the matter could be resolved expeditiously and staff would be protected from future council member abuse. Now, here's the thing. We presented what was it called? It was a code of conduct. And just thoroughly got trashed for doing it. So, and I think it's been tabled, hell, it may even be dead, I
I
don't know.
think
It's
that one's gone.
It's dead, yeah.
So, you know, there's that, that's,
Well, Steve, to John's point, when you read that, he's already saying, I have to take responsibility for my actions. Well, what actions are those, you know? And so he's already laming guilt there, and I think that's
Oh,
what
sure,
John
and
was
he-
trying.
And he did from the beginning,
Sure.
because he'd done the investigation, and he
Sure.
said right up front that nothing we do is gonna change the evidence that he has.
Not even my evidence?
Well, no, the evidence that he has.
No, I know, but I'm saying,
Well-
not even my evidence. Like,
He don't know what yours is. That's-
exactly, and that's kind of why
and
we're
that's-
here.
and
That's the
why-
point.
That's the point.
And that's why we need to have a
He-
public hearing
he-
to get everything out into the open.
If you look
then
at every
we
one of these
decide.
charges, they're hearsay and speculation and subjectiveness, and so, listen, I don't really know. All I'm saying is, it's pretty easy to stand there and listen to one side and come up with all these allegations, and they make them sound so damning, and nothing will change my mind. Well, then like John said, just vote me off and be done with it. I mean, I'd rather you do that than waste money going through a hearing. And then I'll go out as a citizen in public, all my evidence, and we'll go that route. I mean, but that's the point. He hasn't given any reasonable time frame for me to respond to anything to him, talk to him. He has no idea what the other side is, and none of you do.
Have you not had 2 months to contact him?
Why would I contact him? I have an attorney. You guys made me get an attorney.
Okay, so has your attorney in 2 months not had opportunity to make contact?
They're waiting on direction from us.
That's what
I'm
his
not,
letter said.
Phil, what you're asking me to do is just spend money with not knowing what I'm going to be doing. And that's something that I don't think you guys really get. You, like I said 4 weeks ago, you have no skin in the game. So I'm the only one forking out thousands of dollars for an attorney here. And I guess at the end of it, if I come out being not guilty, you willing to pay that bill? That's kind of the point. Like, you're not even listening to any evidence, and maybe you think I have none. Fine, go ahead. But you're also opening yourself to litigation from the other side. I've been trying to say to people, just slow down and talk to me, but nobody wants to talk to me, so then I had to get an attorney. And I don't know any attorney in the country that's going to let me come up here and supply my evidence to you right now. He's going to advise against that, and if I'm paying him, I'm going to say, yes, sir, I won't do that. So now here we are, and I think some people got a hold of the idea that we can do this and not cost a lot of people a lot of money and show the evidence. But you guys have to decide. For the life of me, I don't understand it. Like John said, just whiplash straight to trial. We're not even going to ask about these allegations. What's your side? Not one of you have asked me that. And it's disheartening. And which is why it comes to my conclusion that y'all think I'm guilty right out of the gate. And certainly the prosecutor took zero time to look at the other side, and, you know, that's fine. Apparently that's why whoever hired him was to do a cutthroat job, and he's doing a good job of it. But, you know, and in his letter he talked about the unnecessary stress on the staff, and I'm glad he's worried about them, but he seems very little cared about any stress on my family or my children or me. It's just attack, attack, attack. So I guess I would like, at the end of the day, some guidance. Either we're going to sit down like big men and boys and girls and have a discussion, or go to mediation and let's get it over with.
Josh, is this too much to ask? We just need direction. We need direction, structure, and just bring it back to us, and then we can figure out what we're gonna do.
I think, so the question was, does it have to be open or closed? If the council got together to discuss?
Yeah, yes, yeah.
How do we get that answer like 10 minutes ago? So where does that, I'm sorry, microphone, sorry. Where does that, if that is a point that we need to know, a detail we need to know, or I guess it probably doesn't matter, how do we move forward?
I can give you my opinion on that. I'll take a look at that and, see if it falls under one of the exceptions for which a meeting can be closed, and I can advise the mayor or the city administrator of what that opinion is, and then the council can make a determination, whether to have whatever that is, whether to have a closed or open session, then depending on what that outcome is. I will say the way I envisioned, and I don't know what Mr. Martin had in mind, but the correspondence that was sent, the way I envisioned that was that there would be some discussion between Mr. Green's counsel and Mr. Martin about whether, there were facts, if any, that could be agreed upon. And that as part of that process, then if there was some resolution reached, that would be presented to council, and the council would have an opportunity to determine whether whatever agreements had been reached were satisfactory to the council or not. And so I think to answer that question, the way at least I would envision it happening would be there would be some discussion of what facts or, if any, could be agreed upon between, the parties that are involved in that. outside of outside of the hearing context.
And toward that end, I think we need a deadline.
Is there a time frame on that?
I mean, I think, that, I guess, if the council would like, I'd be happy to reach out to Mr. Martin tomorrow, ask what, if any, progress has been made on that, and then, ask him to provide an update, not to me, but to the council, as to what steps, if any, have been taken, to move forward with the statement in the letter, that he provided to the council.
Well, what would it take for you to get back to us on whether we have to have an open or closed session to just have a discussion amongst ourselves without even getting the other prosecution in?
Just a bit of legal research and a note to the mayor or the city administrator.
So this could be something we could probably address after you get us information on Monday night.
Yeah, I'd be happy to.
I mean, we've got a council meeting coming up Monday night.
Ahead of that meeting, make sure I've got something out to council, yeah.
And I can tell you, since that letter, they have not spoke.
Yeah, I know, I know
And,
you indicated.
and I go back to what I said, every time you have them speak, the clock is running. So when I heard about possibility of a different outcome or whatever, I didn't, I told him, don't spend any money. So if you want me to have them discuss that or wait till Monday, let me know. But yeah, I don't unnecessarily have him doing work when I don't really know what end game I'm working for. So.
Makes sense.
And I'm looking at what you just read, Steve, I think that would be a possibility of working, but I'd still go back to the fact that we have to know what the facts are. I mean, maybe you answer your allegations, maybe we investigate, and in the end, we're gonna have to find out, did you do nothing wrong? Were you wrong on counts 1, 3, 4, 5,
Right.
before we can make a determination.
Right.
So, we gotta have the facts. We
And I
can't-
have answered those, just not to you all, because you made me
Okay.
hire an attorney. So I answered them
Right,
to
you
him.
answered them to your attorney.
I
but-
went through every one of them and wrote long statements and answered
Okay,
every one of them to him. So now they have the facts. Now, my attorney hasn't obviously interviewed the people involved, which he'd probably want to do at some point if we're gonna keep going. And that's one of the reasons I've told him to, stop doing anything until, I don't wanna spend 5, 6, 7, 8 hours interviewing people
yeah.
at that rate if I don't need to interview people. I mean, he's got my responses, can they talk about it, whatever from that point, yeah.
Well, there'd be a list of individuals, and you'd probably, like any other trial, you'd do depositions,
Right,
or you'd sit down and, you and then the other party would, and it's under oath, and plus whatever hard evidence they have to present to, and then hopefully they could make a determination then. I mean, I'm still having a hard time seeing how this is gonna happen without going to a hearing, and I don't wanna go to a hearing. I don't wanna deal with any of this.
I don't either.
I wanna move on, but I wanna do it the best way, and I wanna do it the right way. Maybe there are 3 right ways, and we can do one of them, but I wanna come out with the right determination in the end, and I wanna get on with this. So,
So Josh, you're gonna do that regardless?
Yes, and then I will reach out to Mr. Martin and ask him to provide the council with an update, or some kind of timeline for doing what he suggested in his most recent correspondence to the city.
okay.
Do you want your attorney involved in that, Drew?
well, depending on,
Yeah, he would have to be,
Yeah.
the suggestion.
At least
there was-
copied.
yeah, I mean, if you're gonna talk timelines and things and what, how involved, getting ready for a trial is way more involved than sitting down with my statements. Josh, would that be an accurate statement?
Yeah,
And
I would think so.
so, yeah, he's gonna need to know and be involved in whatever timeline is proposed to have a deposition
So
or.
you might instruct Mr. Martin at that time to, when he copies us, to copy Mr. Kenny as well. And then if by Monday night, Drew would have any objections to what he's hearing, or Mr. Kenny, then we could continue with that. But if not, maybe we'll have a framework that we can deal with on Monday night.
And if you want me to have him call Mr. Martin before Monday and talk about what his letter says, I can do that. Or if you want me just to wait until Monday. I just don't want to get to Monday and now, you were supposed to have, tell me what I need to have for you Monday, because I don't want to slow the process down.
Yeah, I would just ask, I will ask Mr. Martin to provide some kind of time frame, and then if there's some response to that, to me, that indicates that, he needs your counsel being involved, I'll communicate with the mayor, make sure that message gets passed along to you then, so that you can contact him and
Okay.
go forward then.
Okay, I'll wait to hear from you then.
Sounds good.
Well, a question that's been bothering me a little bit is, when we talk about the city of Marshall, there's a couple different ways we always look at it, like the city council's part of the city of Marshall and that standing structure. And if nobody on city council hired Mr. Kerman, then who did? And why do we let the allegations and all these things add up so fast? Or why do we let it add up so much with never actually anybody talking to Drew before we had enough evidence to take it to trial? It seems more or less,
The city council did hire Mr. Kerman. I mean, I don't think any of us was here when it happened, maybe Dan.
I think it was 21, right? 2021.
but then somebody had to start or have all these allegations and start an investigation though, right? And that wasn't any council member?
Mr. Kerman applied for the job.
Are you talking about
We had a
Mr.
city
Martin or
administrator.
Mr. Kerman?
Martin, sorry.
Martin,
Oh,
okay.
okay.
I'm sorry.
Okay,
No.
Thought I was
okay.
confused.
No, the lawyer.
Yeah, Mr. Martin, yeah.
So if we hired him, but regardless, somewhere along the line, instead of having a discussion with Drew Green, nobody did, and then now we're here to this position where we have to have a lot of lawyers in it. But if he was doing something wrong for multiple times over months and months, why wasn't something said or brought up to the councilmen themselves early on, instead of it going into this landslide that nobody even has any information on?
I
And-
don't know, man.
I really feel like, I'd really like that answer, to know why was nothing ever said to any sitting council member or Drew himself to let him know what was going on? Because it just seems ridiculous that it got to this position that we're in, and I understand, like, everybody does want it done, but that's a big question to know who brought it on and who let it get to this position, because everybody nobody really knew what was going on with Mr. Martin, started reading all those accusations and bringing up the court battle itself. So,
Well, my answer to that would be, I don't know if anybody on the city council knows what's going on. I would assume that a city employee made a complaint to their supervisor. And I don't know what should have happened at that point. I don't know what happened and what didn't happen. But for whatever reason, this investigation was undertook. And that's how we got to where we are. It's kind of like when the hired hand is not paying attention, he dumps an extra truckload of grain in the bin and it's already full. Okay, there was a screw up there somewhere, but now we got, 1,000 bushels of corn on the ground. That sort of thing. We just gotta deal with it. And that's what we're doing now. We're just dealing with what was dropped in our laps.
Cause and effect.
And none of us here are really eager about this, and none of us here really know how to handle this. I mean, I've been on disciplinary committees before, and arbitration committees and things like that, but they're all different, and they've all got their own set of circumstances, but until first off, you learn what the charges were, what the charges were, and then you figure out what all the details to those were, and then you work out what to do about it. And I think we're at the part now where we need to figure out some way to figure out what the details are, so then we can figure out what to do about it.
Yeah,
And this letter here says it need not be overly damning, so, do these things rise to the level of voting them off the island, so to speak, or do they just rise to the level of, okay, we, I don't know, make apologies or something, and then we move on. We don't know, because we don't know what we don't know.
So if Mr. Martin has already taken depositions from witnesses and gained his case, and the city of Marshall has paid Mr. Martin, would that information be available to us to then use as your witness statements and everything else, so that we can hear Drew's side? Because we don't technically need to go out and find all this information if we've actually been billed for said information. Because nobody does want to run and have to find all this information, and let alone if you know somebody or not. But Mr. Martin, if he's done this like he says, then he should have the information at hand for us to look over, while Drew could get his own. But we just need to develop a framework, whether we can have this in open session or closed session, to find out whether we can do this ourselves.
I guess we'll know that Monday night.
All right.
And to Nathan's point, I do want to make a statement here. I'm going to try to be as vague as possible because I want to leave third parties out of this. And Dan, you'll have to answer probably this question. You've been up here a while. But I know in the past that allegations have been made from city employees against council members, and that those council members have been brought in and discussed privately the matter. And it didn't snowball into what Nathan's saying. And so I think he's got a good question, because in the past, it has been handled differently. So Nathan's got a good point. And Steve, I understand what you're saying, and you may not have known what I just said has happened up here before, but it has been handled differently in the past. So I don't know why it can't be handled that way this time. But it did snowball to where we are. But I just wanted to make a point that, and Dan knows these facts, and I'm going to leave them very vague, but it has happened that way in the past, where individuals have been called in with employee complaints and not risen to this occasion. So.
Do we have any motions, or are we going to let Monday take care of itself?
I got just one last question, not to delay anything.
No, it's your call.
So the end result to this, if I understand, the worst case scenario is a dismissal from council with vote after trial or before trial, I mean, whatever that looks like, or an apology. I mean, it seems like the two outcomes. I mean, what other outcomes could there be? It's not like a 3-game suspension. You know, I mean, those are our true outcomes, right? It's dismissal, or let's figure out where things went wrong. Are there things to be held accountable for, admit accountability, and find out to move from there? I'm just trying to, what are our true outcomes? Josh, this.
Dismissal, censure, removal.
Okay. Okay. Thank you.
Yeah, there's some other levels in between what you're saying, apologies and dismissal.
What are the other, that's what I'm
Well,
asking.
that's something we'd have to sit down and discuss.
So it could be a 3-meeting suspension?
I don't.
It could be.
Yeah,
No, what's in
There
between?
might be some compensation
Okay,
if somebody felt wronged or something like that.
Gotcha.
There's a whole lot of options that could be discussed, so
okay,
I can't list them off. I don't know.
okay.
And I'm not saying that, it has to go to trial, but I think that's where the two lawyers coming together, at least to discuss it, is probably a good idea, so that we get their professional opinion as to what has happened either way, right or wrong. I feel like that one lawyer's already done his research, the other lawyer's gonna do his research, and they get together and explore both sides, I think is probably minimizing the hours that it will take versus doing a full-blown hearing, which could take days, rather than than them getting together and discussing how many of the allegations are there that are true or false. And I think they can give guidance, I feel like they could give guidance to us as to their thoughts from both sides. And that's how I feel about it. I don't think that's poorly spent money to have a professional's opinion at this point on that.
Any further discussion or motions or suggestions?
I'd make a motion to adjourn and go home.
I'll second that.
Okay. All in favor? Oh, I'm sorry, we have to call roll on that. Although that's gonna change. That's gonna change. We're going to go back to the old way, but we'll talk about that Monday. Okay. Clerk, call the roll.
Cook,
Cook what? Yes, yes.
Allen,
Yes.
Halfway out the door.
Perkins,
Yes.
Green,
Yes.
Swisher,
Yes.
Guthrie, Thompson,
Yes.
Brandt.
Yes.
We're adjourned. Thank you, everybody. I'll stick around and talk to you guys as soon as everybody's cleared out. Just come on down and talk
I
to
got a
you.
question right now while everybody's here. That's okay?
Yeah, it's not a council meeting. They can leave if they like.
I'll get it out quick before they run out the door. On the open and closed session, the sunshine law doesn't say you have to close a meeting. It says you may close a meeting for one of the 22 enumerated reasons. And yes, Mr. City Attorney, you can dig through there and find whatever loophole you can, but I would encourage all of you to do this in open session. There's no reason to do it in closed session. It's a public officer, it's an elected person. It all has to be done in open meetings. If it's done in closed, I don't think the community's gonna like it.
Thank you, Tom.
Yeah.
Everybody else? Or we can all leave? Okay.